Hello, everyone. I'm Natalie Paul from Wellman, Weinberg & Reese. I'm an attorney here in the Philly office where I specialize in subrogation. I would like to thank you for joining us on the third out of 4 webinars where we are breaking down the CFPB's final debt collection rule. Today's webinar is going to focus on prohibitions on debt collection communications when there is attorney involvement. Section 1006.6 of the rule is where you can find the prohibitions of debt collection communications when a consumer is represented by an attorney. With respect to represented consumers, the CFPB reiterates the FDCPA language that limits when a debt collector can contact such consumers. Specifically, under the rule, debtors are prohibited from communications with consumers when the collector knows or should know that the consumer is represented by an attorney, or knows or can readily ascertain the attorney's name and address. There are a few exceptions to this prohibition. The first exception is that you may communicate with the consumer if their attorney does not respond in a reasonable amount of time. Please note that the CFPB does not define reasonable time, so they have not provided very much guidance with this rule. The second exception is you can communicate with the consumer if their attorney consents to the communication. With the third exception, the CFPB has provided us with some guidance. Commenters told the CFPB, hey, look, we know that consumers are represented by counsel, but consumers are calling us anyway. What should we do when we know they are represented, but the consumer is calling us anyway? The CFPB addresses this with the third exception. The CFPB confirmed that if a represented consumer initiates a communication with the debt collector, the collector may respond to that specific communication because the consumer's initiation is deemed to be prior consent to that communication. So here, an inbound call from the consumer doesn't eliminate the prohibition on communications with that consumer, except that the collector is allowed to communicate with the consumer on that specific inbound call. Keep in mind that a consumer may also tell a collector they are no longer represented. This particular expression by the consumer eliminates the prohibition moving forward. That collector can now communicate with the consumer unrestricted. The final exception is that you may communicate with the consumer if the court authorizes the communication. All right, that concludes today's presentation. A lot of what I discussed is information that you may have known, but the CFPB did provide us with some guidance with the final rule. Thank you for joining us today. If you have any questions, please feel free to reach me. Thank you.